Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Whoo, y'all. So today we are going to talk about Justine Washington, aka Danny. I believe some of you know her with Corey and Miss Sherell Hodge. And Miss Sherell Hodge is the individual that I'm familiar with when, who was that? Keith Lee, who came to Dallas and he gave $4,000 to the food truck and the lady didn't pay Sherell and some other individuals. That's Sherell there. So y'all know I've been on a hiatus, and during my hiatus, I still scroll through social media and was on TikTok, and I actually followed Sherell, and this case came across my timeline, and I just tapped into it to hear what Sherell had to say, and she had me dying. I don't know too much about Danny and Corey other than what I see on some of the YouTubers' platforms, but Sherell had me dying. So we are going to talk about that lawsuit. But first, I do want to talk about the eviction. Now, I couldn't find any other eviction that was filed. I know that they were saying that Danny got kicked out of. I don't even know if it was her house. I don't know. Based off of what I seen on another YouTube channel was that she was stating that I guess there was a business that she had and she didn't feel the need for paying for something. I don't even know what that had to do with the eviction, but this is what I found on my end. So let me go to Tarrant County. Okay, so this is the eviction for a property. I don't know what property it is. I do know it is in Tarrant County. Um, Chastine on her petitions have listed a Montgomery, Texas address and a Frisco, Texas address. Frisco's in Collin County, while Montgomery, Texas, I believe, is in Montgomery County. But I'm like, okay, so and I actually ended up Googling the address that it has listed for the defendant, which is Danny, and it's a nice house. So I'm like, what type of house is this? Anywho's, if y'all look here, you might have to squint your eyes. An eviction was actually filed on September 5th. And let's see. They served her on the 10th. The return of service was filed on the 11th. They had an eviction hearing on the 27th. Whatever went down. Oh, okay. So it says mailed default, meaning that she never showed up for court. So anytime you fail to answer or respond to the served petition, or the service showing that you've been sued, that's an automatic default. And in an eviction case, because an eviction case is in like the just like a small claim or justice of the peace court, because and it's funny because my one of the attorneys, he was cracking me up. He was like, the small claims or justice of the peace judges aren't really like I don't know if he said they aren't really judges. I don't know what he said, but that is the reason why individuals get to actually have an appeal. I was like, oh, that's crazy. But anywho's, so she could have had an opportunity to appeal. She still, I think she still does. It's so many days afterwards that you can actually do the appeal. But child, the default judgment was awarded to the landlord in the case in the amount of $7,173.15. If she was to appeal this, in Texas, you are still, even though you appeal, and I should be saying this, but I am saying it, even though you appeal, you are still responsible for paying rent. Okay. A lot of people who be like, okay, I'm gonna stop the eviction process by appealing. Yes, you can do that. However, you still are responsible for paying rent. So if she does make the appeal, then rent is due in amount of 3,800. The bond is set at 14,000. Okay. But on the flip side, they have already issued a writ of possession. The constable has let me see, it's on the 27th. So as of right now, it's unserved. So meaning that the constable is in the process of trying to um pretty much go take back the house. And let me see, the 27th, that was what? That was Wednesday. So about a week. All right. So I'm going to keep an eye on this one and see what happens. So as of now, um, there's a judgment, a default judgment about $7,000. If they want to appeal it, the bond appeal is set as 14,000. She still will have to pay the rent of 3,800. I don't know if this is related to the evictions that they were talking about earlier because I've seen a totally different company, but who knows? But that is the eviction in Tarrant County. Now we're going to flip over to the lawsuit that she filed against Sherell. Sherell, I hope I'm saying her name right. Now, this one was actually filed in Collin County. Now, so I did review the petition, and you can tell if she did try to get a lawyer, I can possibly tell you right now that they said we probably can't take your case, meaning that's the reason why she filed pro se or self-represented. Um, Anybody can file a lawsuit. If you push me, or even if you stepped on my pinky toe, I can file a lawsuit against you. Now, an attorney may not take my lawsuit, but that doesn't mean that I cannot file a lawsuit. I just have to prove that you injured me by stepping on my pinky toe. So I have to, the burden is always on the plaintiff. You have to, in lamest terms, you have to show that, an injury was caused by this person, okay? Or the other party or individual or entity. So I'm going to go over the petition, and I don't want y'all to laugh, but Danny filed the petition. Sherell responded. And then Sherell responded with receipts, y'all. When I say receipts, I was cracking up the whole time I'm reading this. I was like, what? All right, so both of these parties don't have an attorney. They're both pro se. This is the docket. It was filed on the 3rd of September. In addition to Danny filing a petition, she also filed a temporary restraining order, and let me see, a temporary injunction. Yep. Just meaning that, and everybody think about a temporary restraining order is just about, okay, we can't go in, so many feet of somebody. It could range from a lot of things, from the other party not talking bad about you, not withdrawing money out the account, all kinds of stuff. All right. I didn't pull it only because it's not really necessary. But she filed a restraining order and a temporary injunction. I'm gonna go through the docket and we're gonna go to the petition. They heard that on the 12th, and let's see, ex parte temporary restraining order with an order setting hearing for that. It was heard on the 12th. Case was called. Petitioner and respondent were both present and announced ready. Testimony present. Motion for TRO is granted. Order to be submitted. No posting to social media. And okay, so I didn't like I said, it could be for anything. It doesn't have to be and I'm talking about the TRO, a temporary restraining order. It doesn't have to be like applies to distance. So here What the judge ordered Sherell not to do is to post on social media or no entering the place of business of the petitioner. So Sherell can't talk about uh Danni at all on social media, none of her platforms. And I'm pretty sure what will happen, but they don't have an attorney, or Danni doesn't have an attorney, so it's not like she's going to pull her, subpoena her social media records. But I'm pretty sure Sherell is following because, once again, this is an order signed by the judge. But on the 18th, Sherell filed a counterclaim for defamation, invasion of privacy, intentional infliction of emotional distress, and a violation of Texas revenge. And that is that word, corn law. Y'all, I tell y'all, it's about to be nasty. And I know Sherell's about to have a field day. All right. So let's hop on into, I'm going to share the PDFs. Let me pull that up, y'all. Ooh, where I put my y'all? Hold on, I want to switch screens. Okay. Oh, y'all, it's crazy. Now, okay. So she must went to the law library to pull this because I don't draft mine like this. But anywho's, this is the petition that was started and filed by Danni, aka Chestine Washington. Let's see. She is seeking $100,000 or less in just non-monetary relief. Okay. So $100,000 or less, and non-monetary relief. Let's see. I'm gonna get down to what this is. Now, I'm just gonna read this, y'all, and y'all could just y'all make y'all own draw your own conclusions. Number 6 says relationship of the parties. Briefly explain how the plaintiff and defendant know one another. Danni responded, I do not know this person personally, but she has been threatening me on the internet and have shown up to my place of business twice. Number 7, wrongful conduct. Beginning on or about February 2024, the defendant has engaged in a course of conduct that was reasonably likely to harass, annoy, alarm, torment, or embarrass the plaintiff. In particular, defendant has threatened irreparable harm to the plaintiff by, and you have to describe in detail what has happened that led to this lawsuit by listing the specific facts of the defendant's wrongful conduct. Sherell Hodge has been posting all over YouTube and other platforms that she is going to physically harm me whenever I visit my dessert shop located in Frisco, Texas. She showed up twice too, and I don't want to put, oh, that's the business address anyway, the Peach Cobbler Factory, my employees, and threatening me. So she showed up to Peach Cobbler Factory, threatening her. That's what she's claiming. I have videos of her violent behaviors. Plaintiff supports this claim by attaching evidence in the form of a declaration of videos. All right. Now it's supposed to be declaration of in the name of the person. This declaration is attached to this petition as exhibit. So first of all, she didn't even do this part right. So, anywho's, click here to add a cause of action. So she clicked there. Then she checked off, clicked here for stalking. What else? Because of defendant's harassing behavior, the plaintiff reasonably feared for her safety. The defendants, by acts or words, threatened to inflict bodily injury on the claimant, commit an offense against the claimant. Uh, let's see what else. She didn't check this box, but then she did put the defendant acted intentionally or recklessly when the defendant And then she goes to say the defendant has been posting videos all over the media, driving 50 miles from her home to Frisco, causing defamation of character to my business. Now I'm going to tell you guys this. Um, from where Sherell lives to the peach cobbler factory, it is not 50 miles. I'm in Richardson Garland border, and my aunt lives in Little M, and that's north. It taking me about a good 30 minutes to get there, and that's about 20 something miles. So I know for a fact I lived in Louisville and Frisco. She ain't driving no 50 miles. But anywho's, that's the exaggeration. Anywho's, the defendant conduct was extreme and outrageous. Describe how defendant's conduct was so extreme it went beyond basic insults, threats, or annoyances because she's going to put threats, walking into my store twice. The actions of the defendant caused the plaintiff emotional distress. Specifically, it caused the plaintiff to suffer in the following ways: mental suffering, depression, anxiety, and I cannot focus. You got to show medical records for this. You got to prove up your damages. The emotional distress suffered by the plaintiff was severe in that and it says, describe how the emotional distress was so intense that no reasonable person could be expected to handle it. Since February 2024, this person has been harassing me and leaking my home address. She has been threatening me as well. So, therefore, it has caused mental suffering. Check here if you're claiming defendant breached your privacy. Defendant's wrongful conduct is a breach of privacy because defendant intentionally intruded on plaintiff's solitude, private affairs, or concerns when defendant has leaked addresses to all my homes. She further goes on to say, let's see, it says, check here if there is another cause of action created by defendant's conduct. She did not check here, but yet she puts threats, trespass, defamation of character. Describe the cause of action if not listed above or if in addition to the examples above. Threat, posting videos stating she is going to harm me and visiting my store twice. I'm telling you guys right now, this is not checked. Like, a lot of people don't realize the judges, especially if you are pro se, they are going to be on your behind. This was poorly drafted. Okay. Um, and you're not following the directions of this form. Like, you're not checking, you're listing, but you're not checking, you're not properly responding to the questions or the statements that is on the form. So it's going to be a little difficult. Let's see. 8 says plaintiff has suffered harm, damage, and injury due to defendant's acts listed in paragraph 7 above by. And it says, well, let me read this box. It says, describe the damages or injury. This could include, for example, strained relationships, loss of reputation, lost sleep, psychiatric diagnosis. It says describe it. Okay. Loss of reputation. Okay. How was your reputation lost? Mental suffering. What caused your mental suffering? You got to give examples. You got to give a little bit more detail. And I'm pretty sure that's probably why, they both got to go before the judge and she got to explain. So, that's why she got the TRO. So something is there. Unless this court grants plaintiff request ordering defendant to stop, plaintiff will continue to suffer irreparable harm, damage, and injury because The threats will stop if granted, but I will still suffer with the loss of reputation because she is stating false information on the internet. Thus, the reason why they say you can't post on social media and you cannot go to any of her businesses. Let's see. And this is just a temporary restraining order. So it's just saying, Sherell can't communicate with Danni. She can't threaten Danni. She can't place no phone calls to Danni. Let's see. She can't even so she can't threaten her with bodily injury. But here she can't threaten her in person, by phone, or in writing. Let's see. And that's it. And then she said, list any other actions or conduct that you request be restrained. Cease and deceased. Cease and desist. This is not a restraint. I mean, as you can see, the TRO was already granted. So, she can't pretty much say her name. But yeah, that's that. What else she said? It is essential for that defendant be restrained from doing and performing the acts described above immediately and without notice hereof and hearing, because defendant is sending threats and she is showing up to my dessert shop daily to physically harm me. I have videos to prove that. Now, you said she showed up twice, but here you saying she's showing up daily. Plaintiff shows that without court intervention, it has no adequate remedy at law for the harm and damage plaintiff has suffered and is suffering as a result of defendant's conduct, because defendant the defendant need to be sued for defamation and character. All right. So this is pretty much what she requested for the court to do, and that's why you see that they had the hearing on the temporary injunction and the TRO, and it was granted. Now, after the judge granted that TRO and temporary injunction, Sherell goes ahead and files a counterclaim for defamation, invasion of privacy, intentional infliction of emotional law. So we have Danni and we have Miss Sherell. So now this is Sherell telling her side of the story and what she is going to countersue Danni for. In April 2024, plaintiff Chastine Daniel Washington engaged in a series of defamation and harassing acts against defendant Sherell Hodge through public social media platforms. This is very well written, by the way, and I know Sherell did this because she does a lot. Plaintiff made false statements alleging that defendant was unfit as a parent, including threats to call CPS without legal basis. What is with folks calling CPS? You got to have some type of legal basis. You just can't call and say blah, 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 blah. You got proof? Can you prove it? So on and so forth. But hey, it's neither here nor there. These false allegations were made with malice, designed to cause severe emotional distress, and were shared with the intent to damage defendant's reputation in the community. Plaintiff further violated defendant's privacy by publicly disclosing defendant's private information, including defendant's home address and intimate images with defendant's consent. These images are obtained from defendant's private subscription service and shared on social media forums, including Facebook. Ooh, cha. Plaintiff's actions have caused defendant significant emotional distress, humiliation, and harm to her reputation. The unauthorized sharing of intimate images constitutes a violation of the Texas Revenge Porn statute. Causes of action. The first one, defamation. All right, so let's see. She made plaintiff, so Danni made multiple false and defamations concerning defendant in regards to her allegations as a parental neglect and the posting of false CPS reports. Let's see what else. Let's see. These statements were libel per se, as they falsely accused defendant of conduct that could subject her to public ridicule and disgrace and were intended to harm her personal reputation and standing in the community. The statements were made publicly on Facebook, a widely viewed social media platform. Under Texas law, statements that injure a person's reputation or falsely accuse them of a crime of immoral act are actionable without proof of actual financial loss. As a result of plaintiff's defamatory statements, defendant has suffered severe emotional distress, public humiliation, and loss of reputation. Defendant is seeking $20,000 in damages for emotional distress. Now, i- in the legal field, some of these statements or language could be an over exaggeration, but it is common to put that language in here. Okay. So when, when it says defendant has suffered severe emotional distress, if we go on Sherell's TikTok at least, it doesn't look like you're, in distress, severe distress, but that's just what I'm saying. Okay. Coming from a paralegal's point of view. But this is what she stated, and this is what she alleged. So she is seeking $20,000 in damages for emotional distress. Count two, evasion of privacy. And this is in regarding to disclosing her private facts, including her home address and intimate images without her consent. And she did quote and reference the Texas law. Let's see, she is also asking for $20,000 in damages for harm. Count three is intentional infliction of emotional distress. This is in regards to her making false CPS allegations and threats to involve strangers in CPS reporting. The publication of intimate images constitutes extreme and outrageous conduct that no reasonable person should be expected to endure. Now, based off of this did cause defendant emotional distress. She cited the Texas law, and she is also seeking $20,000 in damages. Last but not least, the Texas revenge porn law. The unlawful disclosure of intimate visual material. So, by her posting and disclosing those intimate images without Sherell's consent, Sherell is seeking $5,000 in statutory damages for each violation and punitive damages in the amount of $5,000 to punish plaintiff for this willful and malice conduct. All right. So it says plaintiff knew that defendant had a reasonable expectation of privacy with respect to these images, which were obtained from defendant's private online platform. Under this particular law, it is illegal to share or promote intimate visual material of another person without consent, especially when the intent is to cause emotional harm or humiliation. Whoo-wee, punitive damage. Plaintiff conduct was undertaken with malice and intent to harm defendant. As a result, defendant seeks punitive damages in the amount of $5,000 to punish plaintiff and deter similar conduct in the future. So she's asking for $20,000 in defamation and invasion of privacy, $20,000 for intentional infliction of emotional distress, $10,000 in violation of the revenge corn law, $5,000 for the malice nature of plaintiff's conduct. She's also asking for any associated fees, attorney fees that are allowed by law, and any other relief that the court deems just and proper. Now, this is what I've been waiting to show you guys. So Sherell was like, I did not come to play with you. I am going to put this all out. You can't say that you. And the thing is, and I remember when she made the TikTok post, so I guess Danny tried to go on there and delete everything from her social media platform. But one, you got to be quicker than that. But two, it doesn't matter if you delete it because, like you guys already know, it's saved somewhere. All you have to do is subpoena either Meta or whatever social media platform. I know Meta is for Facebook and Instagram, but the other like Twitter and what is that, Snapchat, you would have to subpoena those companies. So it really didn't matter whether she deleted them or not. But let's see what she said. She said, "Child." I don't even know how she sounds. But she made a post. I don't even know what day this is. But it says, "Child, I'm Big Dan. I don't fold. I just get even. I want them kids MF." Mm-hmm. That's what she said. That's what she said. Then she said, "Report number one. I can put this on my to-do list every day and I can have all 300 plus of my con." I don't know what that says. Then it says, "Do not reply." I don't know. Oh, ooh. It says, "Thank you for providing report information. Here's the Associated Texas Department of Family Protective Services reference number." Child. Mm, that's A. Oh, oh, okay. I don't know why this is backwards, but calling CPS is like calling the the food stamp office, baby. I'm trying to read backwards. So calling CPS is like calling the food stamp office. And then here's the CPS number. And then I'm gonna read this backwards. I just don't understand it. I didn't have I didn't have something of my kid custody of my kids. I wouldn't have the time to. I don't need the day of being the social media. Something she said, or be on social media or something like that. Report number two. Thank you for providing report information here. Now, see, now this is crazy. You are reporting this like you are voting for somebody off American Idol. This is ridiculous. Report number three. My people move very quick. Oh, so you was having other people abuse the system. That's what you're doing. So you pretty much are taking away from the kids that actually need help. That's what you were doing. Manager, I'm running your social media pages from now on. Now I'm in trouble. I can't even play with the little boy. It's sad when you got volunteers. Yes. Can you send me the information on how to report her? Mm-mm. To everyone else that's inboxing me on how to report her, I've replied with her full name, address on file, and phone number. The reports are not false because she's clearly using the story of not having her kids to brag and boast. This is just to show you that a person like her shouldn't even have those children in her presence again. Please send me your, and I'm pretty sure she's asking about the information. Report number 7. So that's report 6 and 7. And then here's the intimate images. Mm, that's all I gotta say. And that's it. That's it. That I don't even know what to say. Um as I said it before, I am not really into the Danny and Corey shenanigans, but I do follow Sherell. And when I seen this, I was like, oh my gosh, what's really going on? But I don't know if Danny and Corey got a lot going on right now. I'm not, like I said, I don't follow their stories, so I don't know too much. But what I do know is that this particular lawsuit, I want to see how far it goes. In my personal opinion, do I think that Danny's going to walk away with nothing? I don't think so. She does have to prove a lot of things, especially if she does have video, but I'm not sure that she knows the litigation process as well as Sherelle does, so it's going to be a little bit difficult for her. But I'm going to keep an eye out on this to see what the next move is going to be. Uh, since this is in the district court, the next process is depositions, and then after deposition, well, actually discovery. So and I don't know how well Sherell knows the litigation process, but usually in this type of instance, you have to go through discovery, then you go through depositions, and then you go through mediation. If excuse me, if mediation doesn't work, then you go to trial. So I'm gonna keep an eye out on this, but y'all, please tell me what y'all think. What is going on with Danny? Uh, do y'all think she actually now, man? Ooh we, I wish I could show you. It's a nice ass house. That the house that was in the eviction. It is a nice two-story house. I gotta do some more investigation because I gotta see if she actually owns that house. Because if she, no, she don't. Because wow, I'm so slow. Rewind, delete. So no, she don't own it because if she did, she wouldn't be getting evicted out of it. Duh, Cassandra. It's time to go to bed. But anyways, y'all let me think. Y'all let me know what y'all think about that. Let me know what you think about this civil lawsuit against Sherell Hodge. Leave it in the comments below. Don't forget to like, share, and subscribe. Until then, be blessed, and I am out. Bye.